Hi, this is Jackie Mosney with UC Berkeley's IEOR 190G. Today I will be discussing Barnes & Noble and their patent litigation with Microsoft. This is a continuation of their case that actually began in early February. So since a full trial on the case was scheduled to begin February 6, 2012, it's now been in court, so there's been no recent news. So I'm simply recapping on what has happened. So the Nook color is now a target of Microsoft's lawsuit. In early February's ruling, Barnes & Noble's defense against claims brought last year by Microsoft that the Nook e-reader and that the Nook color tablet infringed on the software giant's patents. Microsoft accused Barnes & Noble of violating specific patents that cover the way the user tabs through various screens on the Nook to find information, as well as the way they interact with the document and with the ebooks. In the new filings, Barnes & Noble also blasted Microsoft for tactics of seeking licensing fees from the device makers that use Google Android's mobile operating system, which powers the Nook and the Nook devices. Barnes & Noble waged an antitrust campaign against Microsoft, claiming that Microsoft was attempting to crush the Android operating system by improperly asserting its patents against them. Microsoft's patent dispute with Barnes & Noble is not even close to being over, as the judge of the International Trade Commission, also called the ITC, rejected the bookseller's patent misuse claim, so a big loss for Barnes & Noble. The ITC judge, Theodore Essex, threw out Barnes & Noble's argument that Microsoft was misusing its patents against the Android and effectively nullified the company's major defense against them. Essex's decision is still subject to review over a 6-member panel, but Microsoft is already celebrating what they think will become a win. A quote from them says, "Today's action by the ITC makes it clear that Barnes & Noble's patent misuse defense was meritless," says Microsoft Deputy General Counsel David Howard. And they said in this statement that this case is only about one thing: patent infringement by Barnes & Noble's Android-based devices. Barnes & Noble's in this case said that they had no comment. As Jay Greeny says in one of his patent blogs, that Barnes & Noble is asking the U.S. International Trade Commission to reconsider its decision made by Essex to dismiss the Barnes & Noble's patent misuse defense in its case against Microsoft. The bookseller argues that the rulings don't address their actual argument or analyze them under appropriate patent laws. I'm not sure exactly where this counsel is taking place, but as we've learned, where the specific courthouse is and who the judge is does make a difference on the ruling, because specific judges tend to go either right or left with their answers. In this case, Essex is being more traditional by favoring with Microsoft, a huge company in the IT world, but Barnes & Noble is determined to go through with this, and the fact that they even got this far to go to case really shows that they're trying to stick behind what they're going for in the first place and proving that they're not infringing on the products that they're claiming. Thank you for tuning in for this video. See you next week.